Welcome to the 340Banter podcast. Today we're joined by Mark Ogunsusi as well as Jason Reddish from Powers Law. We'll be discussing recent legal arguments pharmaceutical manufacturers have been using inside the courts, as well as what we see coming down the road in litigation. Even though Mark and Jason are lawyers, you should not use this as legal advice and should consult general counsel.
All right, so 340B has been really rampant in the courtrooms lately, both at the state and the federal level. So I was wondering if we could kind of go through today and get your insights from the legal perspective, both of us being pharmacists, and maybe go through some of the arguments that have come up in those court cases lately.
Yeah, I mean, that sounds like a good idea, but we're going to keep it, related to pharmacists. We're not talking to lawyers, we're talking to pharmacists.
It was a lot easier when there were only like 2 340B cases for the first 30 years to keep track of.
Oh, yeah. Well, we talked about, going through case by case, but we would be here for weeks. So,
Yes.
So we're going to go by...
And we would need a lot of paper in front of us, which would not
We'll go by
helpful.
arguments instead at this point.
Yeah.
So let's kick us off. I think preemption is one of the first ones that had come up. You want to talk us kind of through what that is and how that's played out in the court cases so far?
Yeah, so my pharmacists out there, we're dealing with these state laws that require drugs to be shipped to your pharmacies. And, the drug makers, manufacturers don't like these state laws because they require that these discounted medications that safety net providers provide are shipped to your pharmacies. And they're saying, no, federal law is the absolute, because 340B is a federal pricing statute, right? That's where the price occurs. Say it's absolute, leaves no room for state law. So therefore it preempts the state law. So any state law relating to delivery, and we all know there's all sorts of state laws relating to delivery, wholesaler laws and things of that nature, controlled substance laws related to distribution. But somehow, spontaneously, a federal pricing statute allegedly preempts or supplants or should take the place of or cancels out the state law. And that's preemption. So that's the argument. I don't know if you wanted to get into the disposition of these cases.
So I think we've seen a lot of success at the state level. And so obviously that argument is not working. Is that what we're seeing?
Yeah, at the federal court level, but looking at state laws, they've found that the 340B statute doesn't address delivery. It addresses pricing. It addresses some other aspects of acquiring the drugs, but it doesn't speak to whether drugs have to be shipped to a certain place or whether manufacturers have to ship to where the covered entity wants them to be shipped. So the preemption arguments have largely fallen flat. They were also heard a little bit because on the cases that challenged whether manufacturers could impose restrictions on contract pharmacy restrictions, their whole argument is, well, there's a huge gap in the statute. It just says offer. So we can fill that gap. If there's a huge gap in the statute, it obviously doesn't occupy all of the 340B field, and there was room for state regulation in areas that states typically regulate, shipments.
I want to add to what Jason's saying, is we're talking to pharmacists, right? I mean, how complex is the practice of pharmacy? How many variations do we see? We see institutional pharmacy at hospitals. We see retail pharmacies. We see long-term care pharmacies. We see infusion pharmacies. And state laws govern the practice of pharmacy. In fact, Jason, does the 340 statute even mention the term pharmacy?
No, the word pharmacy is not used anywhere.
Not once.
So why are the drug makers saying that the federal law preempts the state law? I don't know.
All right. Well, then we'll move on from preemption. Next one we've seen is the Dormant Commerce Clause.
Yeah, I mean, that's a mouthful. The Dormant Commerce Clause. Long story short, for my pharmacists out there, they believe these state delivery laws regulate conduct, transactions occurring completely out of the state. It's an old constitutional law concept that interstate commerce, the federal government can regulate. And they're saying that a state law that requires the drug maker to not block or limit delivery of these discounted drugs to the pharmacies, to your pharmacy, regulates out-of-state conduct. Sua sponte, like the drug makers just spontaneously, after years of delivering drugs into states, now states can't regulate these deliveries because somehow some drug makers are located in that state, some drug makers are located in that state. But at the end of the day, they know their drugs are getting to your state. And again, that's another argument that I think is a bit spurious. I haven't seen.
That's a new word for me.
Well, it's unreasonable. It's
Okay.
There we
Wait,
go.
you had sua sponte, but you didn't have
Yeah.
it's unreasonable. I mean, it's like these are old constitutional contentions that have never gone anywhere, and there's plenty of case law establishing that states can regulate delivery of drugs within their borders.
Yeah.
And so, what we've seen is failure by the drug makers on that. In fact, they're dropping that claim. They're not really even including it in their litigation.
And there are plenty of state laws that have impacts on activities outside of the state. I mean, one thing I think of often when you're talking about this, it's called the Dormant Commerce Clause, because the idea is if the federal government can regulate commerce between the states, then states can't do anything that hinders commerce between the
Yeah.
states.
That makes sense.
But you think about, we watched game shows growing up. You've got the California emission standards. Like every car was up to the California emission standards.
Yeah.
They're the biggest market. If they set an emission standard and they're allowed to under state law, that's going to affect everybody out of state because they're probably going to go down to that standard to be able to ship cars to California. So it's not unusual for a state to have a minimum standard for their own state that is going to affect people who want to ship into the state. As long as it applies equally to a drug manufacturer in Arkansas as it does to one in New York, then there's not really an impact.
Yeah,
there.
that's a
That
great
makes sense.
explanation.
All right. So the next one we've got is due process takings.
So this is what they're really kind of focusing on lately, which is that, the government, state or federal government can't take private property from private individuals or entities without just compensation. And so I mentioned this is all about the 340B federal pricing statute. It says nothing about delivery or distribution. But they're alleging that because the statute sets a price that these covered entities can pay, and the state law says you must deliver it to where the covered entities say you should deliver it, that's taking their property. They have patents and they should be able to set their prices unreasonably high. I'm not going to get crazy, but we know drug makers charge 300 to 1,000% in the United States and any other developed country in the world. We know we're being screwed here in the United States, but they're saying that that's a taking and that they weren't justly compensated. But the counter argument to that, similar to with the Inflation Reduction Act for my pharmacists, Medicare negotiated prices, discounted Medicare drugs, is that the drug makers voluntarily participate in the 340B program so that their drugs are covered under Medicare and Medicaid.
The business decision at the end of the day.
Well, it's a really good business decision because how much money do you think these companies are making off of Medicare and Medicaid in exchange for giving some safety net providers critical discounts to keep our country moving? Billions and billions of dollars.
Have we seen that actually go through any court cases yet? Has it been successful?
Actually, on the Inflation Reduction Act side, it's been rejected repeatedly.
The takings cost.
And it actually makes a lot more sense on that side, where they say, I've got this patent window, and now you're telling me that I have to submit to your price, basically, or pay an incredibly high tax. And if I don't, my only other option is drop out of Medicare. And so they're saying we're being hijacked to do it. And the counter argument is Medicare is the biggest drug market in the world. It's one of the best payers in the world. If you want access to that market, you have to play by that market's rules. And for the most part, that is largely succeeded and knocked down the manufacturer arguments. Whether the IRA survives a change in the House or presidency is probably a bigger conversation, or whether it survives with changes is probably a bigger conversation. But the due process arguments have not gotten them over the finish line.
Okay.
You can't take what you're voluntarily participating in.
Yeah. There's an option that the manufacturers could choose to not be part of the pharmacy pricing agreement, which would remove them from Medicaid and Medicare, but would also remove them from the 340B program.
PBM contracts are terrible. You could choose not to contract with the major PBMs. You won't be able to run a pharmacy, but you could choose
Exactly.
that.
Yeah.
Well, of course. So I think one thing to add on to the PBM situation, if I'm a pharmacy, is that I'm not, by signing this PBM contract, making billions and billions of taxpayer dollars. I mean, these drug companies are making massive amounts by, participating in the 340B program because their drugs are covered under a separate program, Medicare, Medicaid, and other programs. I mean, they're killing it. I mean, anyways, I'm not going to get into it. They make a lot of money. Let's just put it that way.
Really? I didn't get that message.
They're doing okay. Yeah.
Stop punching down. Okay.
All right, so we'll move on to the contracts clause. Is the next one we're seeing.
Yeah, this one's pretty simple. The drug makers are saying, by requiring us to deliver drugs to where the patients can actually pick them up, you're modifying our contracts with, let's say, wholesalers or other contracts that they have. And, again, none of these claims have won in any federal court. They're untenable propositions that, really would upset decades-long practice. There's plenty of regulations on it. Let's talk about state-controlled substance laws, right? That modifies a wholesaler contract. There's plenty of state laws that have impacts on your contracts. The bottom line is states are free to protect public health and safety within their borders. I hope the drug makers get with the public health program and stop these spurious arguments.
Yeah, I mean, contracts clause is a tough thing to argue. Basically, there's a line in the Constitution that says no state shall impair the obligation of contracts. But that could be like, I'm going to pass a law that says Logan Yoho doesn't owe his mortgage to that bank in Ohio anymore.
You lucky duck.
Yeah. It's not, there are a lot of exceptions and balancing tests when you're imposing regulations that help health and safety that happen to have an impact on existing contracts. So
one of the things I like about talking through these arguments and explaining them to somebody that's not a lawyer is that what we're seeing is that in some states they're considering this, but there's fears of this litigation.
Yeah.
So it's really good that we're discussing this and showing that these arguments haven't been successful. I think there's value there.
And we went from Arkansas and Louisiana to Arkansas, Louisiana, Maryland, Mississippi, Missouri, Minnesota, Kansas, West Virginia in like 3.5, 4 years. And there were probably another 5 or 6 states that there was fear, well, we don't want to get sued, or we're afraid that we'll get pulled into this litigation. Every time one of these states wins, it makes it easier and easier to pass a law in another state. So maybe we go from 8 now to 15 next year.
Yeah.
Especially if there's fear about what's going to happen at the federal level.
Yeah, I think that could play in as a positive at the state level.
Yeah, when you read the opinions, the judges aren't even, they're duly considering the drug makers' arguments, but they're slapping them down back and forth. Yeah. So really, we were just talking about multinational, highly profitable companies that have the money to sue, to slow down enforcement against them so that they continue to drive up shareholder value and make more money on the backs of our community pharmacies, on the backs of our patients who are in underserved communities, on the backs of our safety net providers and public health providers throughout the country.
Yeah. All right, I'm going to take us to an argument that's not a constitutional argument, but one we're seeing come up, I think, a lot more recently, is the kind of questioning the replenishment system and maintaining the title of the drug.
Yeah, so that fits within a constitutional argument. It fits within, AstraZeneca is alleging that in Arkansas, for example. But it fits within the due process takings, like taking property without just compensation, like patented property. And it fits within the preemption. They're saying that the 340 statute says a covered entity, the safety net provider who's entitled to purchase the drug, shall not transfer the drug to anyone other than a patient of the covered entity.
Yes.
Right? Which has been around since the beginning of time. So the drug makers are saying replenishment, where the drug is dispensed, a drug is dispensed and a drug replenishes the drug. That's all I'm going to say about it. Violates the transfer prohibition, and it's a taking of their property, their discounted drugs. Now, let's just think about it. Replenishment, it's just an inventory accounting system. First in, first out, yada, yada. Has been around since before establishment of the United States. It's well established that when a party has some inventory, especially fungible goods, you don't have to account with detailed particularity one product versus another product. They're fungible, they're interchangeable. For example, when I put money into the bank and the bank mixes that money up with all the other money in the bank, that doesn't mean the bank automatically owns your money. The bank is just holding that money on your behalf.
You're also not getting the exact same, $50 bill back.
You're not getting the serial number. Yeah.
Well, yeah. And look, I'm not going to get into the legal arguments, but at the end of the day, and Jason probably wants to talk more about this, after decades-long practice, replenishment systems were used before 340B was enacted. Under Nonprofit Institution Act, for example, for, own use hospitals. The thing is that after 30 years of practice or more, these drug companies are now all of a sudden saying, we've been dealing with this. This has been going on. It's even more accurate than physically separating the product because you trace each drug on a 11-digit. Every pill that goes out, you make sure that went to a patient, right? They're saying that now it's illegal. Just so you can understand how we feel in the covered entity community. After 30 years, all of a sudden, oh, no, that's illegal. No, you guys are taking my property.
Yeah.
And actually, it's a good segue into everything that manufacturers are looking at that maybe they haven't challenged before.
Yeah.
A lot of people don't know that pharma filed suit against HRSA in 1996 when the first contract pharmacy guidance came out. And they actually pulled it back because of pushback from Ryan White clinics. So, they had an opportunity when this was announced in 1996 to litigate it and fight over whether the program allowed contract pharmacies. They didn't. Now they come back literally 24 years later and they start self-imposing some restrictions on the program.
Does that impact their, have a leg to stand on when you're making that argument when you've not challenged it for 25
There
years?
is a legal concept. It's called laches, which literally means you delayed so long that it's unfair to the person that you're trying to enforce it against. It doesn't apply as often when you're dealing with challenging a government aspect, but it is a factor. I mean, that you voluntarily participated in this model. You knew who you were shipping the drugs to for 20 years, and you didn't balk at it then. But manufacturers are trying to challenge the replenishment model. If you think about risk reward for them, if they were somehow able to get rid of replenishment, you would cut the contract pharmacy market in half. You would have problems with hospitals and split billing.
Hospitals wouldn't be able to manage their
would have to
clinic administered or physician
They would
administered
have to
drugs.
severely limit where they can use 340B.
And a lot of health centers, even their entity-owned pharmacies, are virtual.
Yeah.
in
Depending on
nature.
Medicaid carve-out and things
Yeah.
like that, you may have single neutral inventory there.
Yeah.
So you're talking about maybe cutting the volume of 340B purchasing nationwide by $30 billion. They're going to spend some money to try that.
Yeah.
And it's not for the purpose, let's just be clear. It's not for the purpose of greater, we don't want this because it'll be more accurate if you maintain a separate inventory. Because the second you dispense a drug out of a physically separate inventory to a non-patient, that's diversion, right?
Yeah.
There's no opportunity to true up. There's
You
no
can't fix
opportunity
it.
to
Yeah.
account
Yeah.
for the pills that are fungible, that are
Yeah.
mixable. So it really is just an opportunity to do what Jason is saying, challenging replenishment. It's just to save money. It's just to make money. It's just a multinational profit.
Or to make things more complicated.
So that
to
you
the
can,
point that you can no longer
you can't.
comply.
Mm-hmm.
Yeah.
and therefore then you
Can't
can
use
charge your extremely
Yeah.
300 to 1,000% high list price drugs.
Yeah.
Anyways.
All right, so I've got one more constitutional argument for us to hit on that's been seen in some of the cases we've seen so far, but seems to be less frequent now. Unconstitutional vagueness, which sounds to me just pretty vague. Like it seems like it's pretty self-explanatory.
Yeah.
Yeah.
The bottom line is, if you're going to punish somebody for violating a law, they have to know what they're prohibited from doing. So, if you have a law in the books that says anybody who is performing vagrancy will be charged with a misdemeanor, and you ask somebody what is vagrancy, and they come up with whatever definition they want, that's going to be unconstitutionally vague. You can't create a criminal record for someone because they couldn't possibly know what that means. Manufacturers have tried to argue that some of the language in these state statutes is unconstitutionally vague, and I think they've been shut out on. I know they've been shut out on those, and I think they've stopped really raising that argument.
Yeah, I think they've stopped raising the argument. If you want an opinion, you can look at the Louisiana lawsuits, plural, with Pharma and AstraZeneca, that they lost with flying colors because the law is pretty clear. But unconstitutional vagueness, I mean, a law that says you must not limit delivery of a product is pretty concrete. I mean, what they want to do is obfuscate very clear laws such that they can create grounds to invalidate them and make more money. But at the end of the day, don't limit delivery. Your policy specifically references distribution and limiting distribution and or prohibiting distribution. And that's pretty concrete. And that's why the unconstitutional vagueness argument has not, it doesn't have legs. It hasn't had any legs. Courts basically have said, under basic case law, we can read the statute in a way that's concrete, right?
I mean, if you're writing statutes for a state, if you're helping work on a bill for your state, you can have it in the back of your mind, but the legislative council, one of their jobs when they prepare a bill for the state is to look for constitutional issues. And that's always going to be something they look
Gotcha.
for. So it's already gone through a layer before it gets passed of somebody deciding it's not vague.
All right. So now I kind of want to pivot, and we've talked about the arguments that we've seen that are going on in the courtroom right now or have been, and say, looking forward, what can we expect? Are we going to see some of, a lot of the same arguments, a lot of the same issues? Are we going to see some new issues coming up?
I think new issues. So two things that we've been dealing with, and really one of them is now a year old, is manufacturers, at least one manufacturer, seeking and obtaining permission from HRSA to audit a health center for Medicaid managed care duplicate discounts.
Yeah.
And that's a big deal because for more than a decade, HRSA said, we don't have any jurisdiction over managed care. We're not going to issue, at one point they said, we're going to issue policy in conjunction with CMS on managed care. Then they came back and said, no, we're not.
Just kidding.
Yeah, and the statute itself is written in a way that treats fee-for-service differently than managed care. When they expanded the rebate program to include managed care in 2010, they included a provision that said if the drug's purchased on a 340B account and billed to a managed care plan, it's not eligible for a rebate. We're only prohibited from billing Medicaid for drugs that are eligible for a rebate, so they kind of took it all away from 340B and HRSA. It was a big shock. We fought pretty hard. HRSA did not relent. They allowed this manufacturer to audit the covered entity. The audit actually took place about 7 months ago. We still don't have a response. They rode this health center hard to make them submit documents and move along. And we're not really sure why suddenly HRSA, which has never issued any position of its own on managed care, is now letting a drug manufacturer essentially make up the rules. Because if there's no rule from HRSA to look at, what rule is the manufacturer applying?
And a lot of states have very vague language on
or
how to
non-existent.
prevent a rebate in the MCO
Yeah,
space.
in this particular case, during the time period, there was no rule for managed care claims at the state level and none at the payer level either.
So I have two follow-ups with that, right? So you're saying that's a potential dispute in the future, maybe against HRSA for permitting the audit by the drug maker in the first instance, or even obligating the covered entity in any way to be involved in something that's not responsible for. So my question is, who is responsible? So firstly, what you just said made it seem to me, and correct me if I'm wrong, that once a covered entity chooses to purchase a 340B drug, the rebateability of the drug is extinguished. So therefore, the state can't request a rebate once the covered entity chooses to purchase the drug. Is that right?
Well, the state can write laws and impose rules on when a 340B entity can use 340B drugs to bill MCOs. They can do that through their contracts with the MCOs and tell the MCOs, you're going to tell pharmacies they cannot use 340B drugs, or they can issue a statewide regulation or even pass a law that says you can't use 340B drugs when you bill managed care. A lot of states haven't done anything. There's nothing on the books about how to do it. And you look at each MCO contract or manual, and there's nothing there.
Right.
It's so hard to find information. I know we work with health centers all over the country to find information about even what MCOs, what PBM they're using.
Right. And sometimes you find a bulletin and it's just posted on a website somewhere, and the lawyer will say, this tears up all of my managed care contracts. This bulletin that they just posted, there's no notice and comment. There was no official process. They just put a notice on the website, and now I'm supposed to give up $5 million in managed care bill. I mean, it hasn't been handled well in many states. Some states have, but in many states it was pretty much ignored. And then it got to be a bigger problem for manufacturers. And I think HRSA doesn't really know what to do at this point.
Well, so my question is around the manufacturer audit and HRSA. I guess it could be looked at one of two ways: either condoned it or didn't present a strong front to it. Is the timing of kind of Chevron deference and HRSA having less of a say potentially, playing into that?
I mean, this is actually an area where they have some statutory cover, where the statute says that manufacturers can audit under the basically conditions that the secretary, which is HRSA, allows. So they actually had a little bit of strength here where they put out a policy in accordance with notice and comment that may actually have some legal effect. Now, somebody else could look at it now, post Chevron means a judge could look at it and reach their own interpretation of what that means.
Yeah.
But I think it could have been a political call that, this manufacturer has been beat up pretty bad by HHS on the IRA and some other things. So let's let them have this. It could have just been a poor decision. Or it could be a strategic, we're going to move in this direction. We're going to start here. Maybe they'll sue us. Maybe they won't. And we'll see what happens.
Gotcha.
We just
I
don't
kind
know.
of wonder if when it happened, I kind of wondered if HRSA was afraid of lawsuits. So that's why they just kind of went with the manufacturers.
Which
on
is
that.
really unfair because the health center had an argument that this manufacturer audit should have never been permitted, should have never been allowed to move forward. But to spend 6 figures to be right, you don't get anything back on that. It isn't, there's no award at the end of that case.
Yeah.
You just get HRSA to change what it did. They're not going to do that. The manufacturer might, but the health center is probably not going to invest.
They don't have
the
that.
6
And
figures.
Even if they do, that 6 figures would be patient care money.
Yeah.
Yeah.
It's not sitting in a litigation pool somewhere.
Yeah.
Yeah.
So what other lawsuits potentially could we be seeing in the next few months?
We've seen some startling patient definition audit reports from HRSA. And just to set the table, last November, the Genesis case comes out of a federal court in South Carolina. A judge is finally looking at the way HRSA applies the patient definition and basically says, I'm okay with this 1996 guidance, but these other location timing requirements that you've added on, they're not obvious from the statute. And the hope is, great, now we get to just focus on, do we have a patient relationship? And if we do, we can use 340B, and if we don't, we can't. But we knew HRSA may or may not adopt that entire mindset, but they were probably going to have to go back and change something about the way they were applying location tests and referral tests and things like that. So we knew we wouldn't really get audit reports for a while because the decision comes out in November. If people make changes, it's going to be in December, January, February. Yeah. Then they have to get picked for an audit. And then the audit has to look at that window from March
not
forward.
before.
So we finally started getting some of those shake out of HRSA in September. And we have at least a couple, we've seen probably 4, but at least 2 that we've worked on firsthand where there is a clear hospital or health center encounter for a specific condition. They are referred to a specific provider for a, care exactly following up that prior condition. Full record sharing, HRSA says no. If that's not a valid referral prescription, I don't know what is, because that's been a valid prescription since day one in the 340B program.
I guess my question in those scenarios is covered entity type taken into account because, I think an argument could be made that certain covered entity types have more of a long-standing relationship with the patient, and some are more episodic in nature.
I would say for these cases, it does not appear that they took into account covered entity type. For example, the hospital case, you have someone with a hypertensive emergency, high blood pressure emergency. They treat them in the emergency room. They get admitted for a week. The doctor comes and rounds on them, and then they refer the patient to that same doctor at their private practice that shares records back with the hospital. It's hard to get a tighter link than that between the entire episode of care. And then we had a health center that was also part of this batch that had the usual many encounters with the patient. But this one prescription was an outside provider that they disallowed. And I think if they don't change those audit reports after, for those of you who don't know, you get a 340B audit report, you get to challenge it, then you'll get a final report. If they don't change it before the final report, some of these entities are going to sue, and they're going to basically just cite Genesis as the basis for their suit.
And even though Genesis had that footnote that it only applied to Genesis,
that's relatively common for court cases,
that's normal, isn't it?
Well,
it's the same federal law.
Well, the language is the same for everybody, right? Like, okay, that opinion might have applied to Genesis, but it interpreted the term patient, which is only mentioned once in the 340B statute. And, the plain meaning of the term patient. Miriam does not change based upon the entity type.
Yeah.
Miriam is Miriam is Miriam. So I don't know why HRSA, other than seeking to get another bite at the apple, just for my pharmacists in the room, I'm going to back up. All right. So 340B is a pricing and purchasing statute, significant discounts, and the term patient's mentioned once, and that's what sets the limitation on what you can purchase. If it's your patient, you can purchase. If it's not your patient, we're talking about a physician-patient relationship, a provider-patient relationship, right? We're not talking about provider-patient relationship for every healthcare service that ever happened to this person everywhere in the world. You just have to have a relationship with your patient. Simple. Did you render a service? Well, HRSA is taking it, as Jason mentioned, and applying it across the world in every way. You have to be responsible for everything that ever happens to this patient in order to purchase drugs with 340B. And that's just not what the term patient means. It doesn't mean, everything that ever happens, you have to be responsible for.
And I would recommend, if you're working in this program, that everyone go out and read Genesis. Even as a non-lawyer, it's really easy to understand. It was written in a way that's very approachable.
Yeah.
And it's 33 pages.
There are not dense legal
but
concepts in that.
Yeah,
I didn't have to Google words like I would have had to today.
Exactly.
Because it really all turns on what does the word patient mean?
Yeah.
And what did Congress mean when they used it, 30 years ago?
Yeah.
Well, I have a question. So if you go to your doctor, here's a simple question. If you go to your
You
doctor.
got to make this fast, man.
Okay.
We are running out of time here.
Well, it's simple. When you go to your primary care doctor, and then you've been going to your doctor, and then you go to another doctor, you decide to get a second opinion. Does that mean that primary care doctor is no longer your doctor? No, it's your
I would
doctor
say
is your
no.
doctor.
Yeah.
He's just a patient. It's pretty obvious. But I think the problem is, consistent with congressional intent, covered entities are purchasing a lot of drugs, and HRSA wants to reel that back. She doesn't have the authority to do that.
All right. So knowing that we are running tight on time, I'm going to say final thoughts on litigation. It could be existing or what we anticipate seeing.
I mean, from my side, I would say we're going to see a lot more litigation. We're going to see some litigation flow through the administrative dispute resolution process and be brought through HRSA and then to federal court. And then we will have to see how a new administration will change policy within HHS or within HRSA. If they do, there may not be much change between one administration to the next, or there could be significant change. But things like the rebate model and other things, we have to see what happens.
Yeah, I definitely think we're going to see litigation. I think we're going to get a lot of administrative dispute resolution. We're going to get a lot of manufacturer audits of covered entities. So covered entities, hunker down, get your legal counsel. The drug makers will be auditing you. But I do think that all the courts agree the plain language dictionary definition of terms in a statute is what prevails. So we're getting attacked by the government overbroad. We're getting attacked by the drug makers trying to insert language into the statute where they want to limit 340B purchases. A lot of litigation, but I'm confident that the covered entities will defend themselves properly.
I think it's been a great conversation, and I think we're going to see a lot more coming down the road as we're especially changing executive administrations, and as you said, Jason. So all of this could change tomorrow. It is a point in time, but it's good from a pharmacist perspective to hear an easy explanation of some of these things that are not in our daily vocabulary.
Yeah.